Good afternoon. I am Tammy Garvin, this year's OCAPLTA First Vice President. I would like to introduce you to our guest speaker today, Heath Robinson. He's the Director of Title and A&D for Ascent Resources. Heath has been with Ascent since 2014 and has over 10 years of Appalachia industry experience. His current position involves supervision of Ascent's title team, which orders, reviews, and approves title for all of Ascent's wells. Heath is also responsible for the management of the A&D team at Ascent, overseeing both acquisition and divestiture opportunities for various asset packages. During his time at Ascent, Heath has worked to finalize more than a dozen transactions involving over 300 wells and approximately 300,000 net acres, mineral leasehold, valued in excess of $4 billion. His combined team consists of a diversely experienced team of 8 individuals whose duties expand into multiple facets of Ascent's daily business. Prior to joining Ascent, Heath worked at Chesapeake Energy Corporation in various capacities, including title landman, title attorney, title specialist, title supervisor, and landman 3, with most of his focus being on Ohio, Pennsylvania, and West Virginia. Heath is a graduate of Oklahoma State University and received his law degree from the University of Oklahoma College of Law. He is licensed to practice law in Ohio, Oklahoma, and Pennsylvania. He resides in Okarche, Oklahoma with his wife, Rachel. In his spare time, Heath enjoys traveling, managing his recently owned craft brewery, Expenditure Brewery. It's right across from Ishans. It's my pleasure to introduce you to my friend and colleague, Heath Robinson.
Thank you, Tammy, and I'd like to thank you all for joining me today. I'd like to thank OCAPLTA for having me. We had a little joke going just a little while ago about how you pronounce it, and so I was going to go with OCAPLTA, but I decided to do the abbreviation, I guess. So, but again, thank you all. When Tammy reached out to me about possibly speaking, I told her I had a topic in mind that I've kind of worked on over the years, and I've been asked to do some other speaking deals, so you guys will get the first go at it here. I think it's a topic that kind of goes overlooked. I think it can offer a lot of cost savings and efficiencies in the oil and gas industry, especially from a land and title perspective. So, as you can see, I've titled it Aligning and Dissecting Abstracts and Title Opinions. So we'll go ahead and dive in here. So the first topic we're going to talk about is getting an overview of your area or an overview of your play. So part of this is you're just building a background. And I think this is part of it that may go a little bit, I guess, underappreciated. I think part of this for me is when I was getting into new plays, I would go out and hit the ground and we'd go out and visit these places. And so that's where I'm coming from on this. I highly encourage you to go out and learn your courthouses and learn the systems they have in place. And so by knowing the courthouses and knowing the records in the area, it's only going to help you through every facet downstream as far as title goes. So number one, go out and visit your courthouses. You need to get your boots on the ground, determine what space is available in them, determine how they're laid out. What do the records rooms actually look like? Also, within the courthouses, get to know the actual location of the necessary records you're going to need. Some of them may be in a basement. Some of them may not be in the courthouse at all. They may have them in a different building. They may be blocks down the street. It really just depends on how each county's set up. And I think it's overall important that you know where that's going to be and what it looks like for when you're taking broker crews or abstracting crews inside those courthouses. Also, you're going to want to know the available computer search stations. This is something that I've encountered many times. These courthouses are small. They have limited search computers available. Some of them set up search limits. You can only do so many searches and then it's someone else's turn. Or they have time limits. I've seen some that have a 30-minute time limit. I've seen some that have a 5-minute time limit. So you have to search, get all your searches in really quick, and then go pull your actual documents. So I think it's very important that you know that, know what limitations you may have. And then finally, as you're going around the courthouse, determine what work areas they have available for your staff. They may not have a lot of tables set up. They may accommodate you. They may set some up. We've had we've been lucky with many courthouses. They've worked with us and actually set up additional tables for our abstractors to work. The next thing is, as you're going around the courthouses, visit the county officers when this is strategically feasible. Now, obviously, if you're in there for a clandestine operation and you're trying to get all these leases under the radar, you're not going to want to go in and announce your presence. But when it's feasible, I think it's a really good thing. You can really build a really strong rapport for not only you and your company, but also your crews that are in the courthouse. Next is understand the recording and notice requirements. And you need to know, are you in a grantor-grantee state or are you in a tract index state? And this is very important because it's going to determine how your crews are able to search the courthouse. What are they going to need to look for? Most of my experience, as Tammy outlined, is in Appalachia. Pennsylvania, West Virginia, Ohio are all grantor-grantee states. Oklahoma, for instance, is tract index. And Oklahoma's records are very easy. You can pull that index and you can go to those books and you'll get everything you need right there. When you're doing the grantor-grantee, it's a little bit more intense on the search side. So obviously having this background is only going to help you in preparing what abstract you're going to need and in the manner you're going to put it together. Next, you're going to want to know the recording statutes for the state. Is it a race state? Does it absolutely mean the first person to the courthouse wins? Is it a race notice state? All things are going to be very important for determining how you lay out your documentation. Next is get to know the online resources for both the county and the state. And this is something that I think since I've started in the industry has really grown and developed as technology has in all facets of our life. Many of the counties have their records online. For us in Ohio, I have all but one county has their recorder's office online. However, they only go back to about 30 years. So while it's a handy resource, I can't do all my work from it. But it's definitely something to know that'll help you in different phases. It may be able to relieve bottlenecks you get into at the courthouse. The next thing you're going to want to know, are there any of those court records online? Several of the counties we deal with, we may not be able to pull the actual court filing, but we can look at the docket. We can learn what may affect our lands or what may affect our lessor and what we need to go get. And then finally, the state records. And there are several state agencies that are online, but one that you probably use more often than not would be the Secretary of State for your respective area. So, moving on to the nuances of land title for the area. This is, again, you're building your background, you're building that history of the area. And I think it's very important to learn and understand what your area was and how it came about and what that history is. For instance, you'll want to know statehood time frame. This will play a part in how was the state set up, what does the old land grants look like, was it surveyed, was it a Jeffersonian section based land state. So in Ohio, we're surveyed. Pennsylvania was not. Pennsylvania was land grants given out of the Revolutionary War. Arkansas, it's section township range as well. Oklahoma, it's surveyed. So it definitely plays a part in how you're going to look at your land records and possibly how you're going to put your abstract together and maybe even your unit down the way. You need to know, is it tax parcel ownership? Most of the states I've dealt with up in Appalachia are tax parcel based ownership. And then get to know even more aspects of it. Look and see, have you had historical oil and gas development? And obviously this is something that's going to be a huge driver in what kind of information you're going to be looking for. It's obviously going to give you an idea of how complicated some of your title is. And I think all in all, it's going to help you build the necessary documentation and deliver the product that's going to be most effective and efficient for your team. Next is you want to know things such as historical coal development. That's one of the things in our area, being in Ohio and even most of Appalachia, there was historical coal development. I know that also happens across the United States as well, but it's one thing we really need to know about because it will affect what do I need to do for a drill site, what are we going to have to do from a permitting aspect. The other side is it gives me an idea of what my title may look like in the area. Obviously, as people were developing coal, they were reserving mineral rights because coal had value. And in Ohio, that delivers a direct impact on our oil and gas ownership. So it's, again, just building that familiarity and that knowledge base of what your area is. Next, you're going to want to know some of the land ownership nuances. And these are pretty basic. There can be a lot of them, so I just listed a few here. But get to know the default tenancy. Obviously, like Oklahoma, Ohio, tenants in common. But get to know what other tenancies are out there. Some of them are statutory and some of them they don't recognize. So you want to really know that for the state. The other thing is get to know intestate succession rules. And these are very important because, especially in Appalachia, not everybody filed probates. Not everybody did the documentation that we needed them to do. So this goes hand in hand across any area, across any plate. You will come across intestate succession, and you're going to want to know how it applies, because oftentimes it does change throughout time. Is your state a strips and gores state? What are you going to do with these leftover pieces of land that may have been left off of conveyance, and how do you handle them? Navigable waters. And this is something that I put on here because for me in Appalachia, this is something that was very unique. When we were in Pennsylvania, navigable waters are a very prominent issue. Pennsylvania has a complete log of all of these creeks and rivers that are considered state-owned because they're deemed navigable. They have specific rules as to what is a navigable water. And some of them don't even have water in them year-round, so it's very odd. But it was something you really wanted to kind of pay attention to. In Ohio, for instance, there are no state-owned navigable waters. So it's a big difference just crossing a river. And then you'll want to know, for instance, are there state lands? You probably also want to know if there's federal lands. But it's also going to open your eyes to, okay, what potential impacts is that going to have? What's the state's leasing mechanism? Who is in charge of maintaining and controlling those lands? What's the regulatory body? All things just to help you kind of build out your understanding and knowledge base of the area. Next, you're going to want to obtain and review the title standards. If the state has title standards, it's a very handy tool. It's one of the first things I try to get my hands on. And you can usually get these through the local bar association. Next, you want to gather and review the relevant treatises and case law. Get to understand the basic property law concepts for your state. You're going to want to learn the curative statutes and the methodology behind them. And I've listed a couple here. We have the Marketable Title Act in Ohio. Oklahoma also has a Marketable Title Act, and they don't work the same. They actually can affect things in different ways. There's a Dormant Mineral Act I listed here. Well, in Ohio, we have a Dormant Mineral Act. Kansas has a Dormant Mineral Act. Indiana has a Dormant Mineral Act. None of them work the same way. So it's really getting familiar with how these curative statutes and the methodology behind them plays into your title. Obviously, I put these two in because in my experience in Appalachia, specifically Ohio, we've dealt with this for the entire time that I've been working Ohio. And the case law continues to develop today. We're getting Supreme Court decisions as recent as like a month and a half ago. So these continue to come out. There's cases still pending. And in the areas where the case law is not as refined or not as substantial, for instance, Appalachia compared to Ohio and Texas, you're really going to want to stay on top of it and really get to know how these things work. And finally, I've put on here to visit with experienced title attorneys. And this is something I take a lot of pride in because they'll be able to help you with the application of legal concepts and statutes. And when I started in Ohio, my supervisor at the time and we did a 3-day road trip across eastern Ohio, meeting with various title attorneys, none of which we used at the time in Ohio, but I got to know them and we started to use several of them, and we used them for quite some time. But they were able to give us some of the background on some of these statutes and some of the law, such as the Dormant Mineral Act, because many of them were involved in drafting it. They provided an insight that we weren't really accustomed to or didn't have a foundation for. They could tell us how historically oil and gas worked in Ohio. They could also tell us roughly how they set up their title opinions, from operator to operator. And what we noticed is they had a way of doing things, and it was a little bit different than what we were accustomed to, coming from what we had been doing either in Pennsylvania or Oklahoma. And so they're a very handy resource, and I would definitely advise you to utilize them. And there on the right is just an example of getting to know a little bit of the history of your state. And this is a patent from James Madison in Ohio. Obviously, James Madison is one of the first presidents of the United States. So you're not going to see that in Oklahoma, but it's a pretty interesting piece of history that I'd like to show. So going to the next slide here. Here we're going to dive into the actual abstract. So now you've built your understanding, you have your knowledge base, and you can see here I've defined what an abstract is in accordance with Black's Law. And it really is the history of a piece of land. So you're going to take your understanding and your knowledge base and your history of your area, and now you're going to build the documentation to get you to the next step in the title process. And the first thing I would advise on this slide is build you some standards and guidelines. Create abstracting standards and utilize the knowledge of the area and the laws you have to actually build those out. And include your crew chief in this discussion. You may be using a very seasoned professional crew chief or abstracting crew in the area. They may have insight into the area that you're working that you don't. And so they are a resource, as well as they're going to be your partner in building these out. And I think you start very simple. One of the biggest things that I've worked to do with my team and our abstracting crews is we came up with a naming convention. It's one way we can track everything, and it keeps it simple. We know exactly what we're getting. We also lay out the scope of what our abstracts are going to be. And by scope, this can change depending on your area, depending on your state. Again, it may go back to if you're a Jeffersonian state or if you're basically a grantor grantee state. Because oftentimes what you'll see in a grantor grantee state is it's very metes and bounds driven descriptions. So you'll want to know the scope of your abstract. Is it going to be based on a section? Is it going to be parcel by parcel? Or are you going to run it on a lease basis? Are you going to cover all the lands in that lease in this abstract? Next, you're going to want to know your search timeframes. And the search timeline is very important because it's going to give you your certification dates, and it'll definitely lead to knowing when you may have to update something or when you're going to have to supplement some documentation. Next, it's the specified document timeframes. And this has to do with certain court cases mainly. We use specified timeframes for searches when it gets into judgments or liens or something like that. So it's just something you need to look at, know the documentation you're going to want in there, and are you going to be able to limit it? And again, talk with your crew chief. What are they seeing in the area? How do the laws of the state you're dealing with affect that? Next, it's which county offices to include in your searches. And again, it goes back to having a familiarity with what those courthouses are and what you're going to need to put in and what your needs are going to be. Next, it's required documentation, and have this defined, know what you want. It's recorded documents, secondary sources, and that's one thing that's very tricky because not all the time is it, excuse me, you're not always going to have everything you need necessarily from a recorded standpoint, especially if you get into certain airship type situations. So you're going to know what secondary sources you're going to want and where you're going to pull those from, and then ultimately how you'll incorporate them. But we'll talk about that here in a minute. Know what maps you may want. Know what tax information you may want. And then are there going to be any probates? Are you going to need wills? Certain counties have registers of wills that you can pull. Or are you just going to want the probate cases? And then any miscellaneous documentation you may want. Just set it out and make sure you have a standard and a guideline for your abstractor to hold. And then thresholds for searches is the last topic here. And this is something that I've put in here because it's something that you can help kind of define your abstract and kind of limit some of the workload potentially. And so, for instance, I know I talked about coal in a couple slides under the history aspect of it. Well, this is where I will use a threshold for my abstractors. If I have a tract of land that is under a certain amount of acres, I will tell my abstractor to avoid running coal on it. I don't need them to waste their time on it. I don't need them to include the documentation, which is ultimately going to slow my attorney down if they needed to review it, because chances are it's not going to be a drill site. In Ohio, that's how I'm really worried about coal, is does it affect my drill site? So if a parcel of land is so small that you can't put a pad location on it, there's no reason for me to have them include coal. If for some reason a portion of a drill site would happen to touch this smaller tract of land, then I would just go back and add it. But it's something on the front end I've deemed as unnecessary and something that can make my abstract more efficient and save time. And then finally, the last topic I have is run sheet inclusion versus abstract inclusion. And this is a very interesting category for me, and it comes out of a personal experience I had with a title attorney, in that I was reviewing the opinion and it wasn't matching up with the information that I had in our system, and I couldn't figure out what had happened. And he was showing the ownership a certain way, and I went into the abstract and I found the documentation I was looking for, and I couldn't figure out why the ownership was wrong in the opinion. So I messaged the attorney and we talked, and he said to me that, well, he looked at the run sheet and there wasn't an entry. And I said, well, the documentation's in your abstract, and he literally told me that he only looks at stuff if it's included in the run sheet. Well, that didn't sit very well with me, especially if any of you know me. But so we had a conversation about it, and ultimately what I told him was, well, you're certifying as to the abstract I provided you. And he agreed and altered the opinion, but it really made me think, and it made me take a step back and look at how I'm handling the run sheets and what my abstract include is actually providing. And so that's a very important thing, is what do I put in my run sheet versus what do I just have in my abstract? And we'll get into that a little bit later in the formatting aspect. So next slide. So this is an example of one of our abstracts that we use from Ohio, and you can tell this is the cover page, and you see this is done by Kastner Land. They've been a long-time broker of ours, worked with them for many years, and they've always given us a high-quality product that we appreciate. And as you can see, there's a parcel number listed, and for Ascent, we do separate abstracts for each parcel. And it's just a methodology that we've adopted based on the area that we're in. Again, it goes back to define the scope of your abstract. In Oklahoma, you may want it to be an entire section. For us in Ohio, the approach that we've taken as a company is we're parcel by parcel. And then I have them search in Ohio back to at least 1850. And this coincides with when you see some of the first mineral reservations and some of the first oil and gas production. Rarely do we see a reservation prior to that, but if we do get that hint in our chain of title, then the abstractor has instructions to go back, and they may have to go all the way back to patent, which is one of the previous documents I showed you. And then they'll bring it forward and it'll solve any issue that we have and make sure we haven't left a gap in our title. So the next thing is they include the various offices that we've designated in our standards and guidelines for them to search. Again, the recorder's office. Pennsylvania, you may call it the prothonotary office. You'll have the probate office. You'll have the court clerk's office, the genealogy office. This has actually been a pretty handy tool for us in Ohio. Many times it's ran by volunteers, but they have a really good understanding of the people in the area and can help you with some of the historic families and stuff. So you never know what you might find in there, but it's something that we ask our abstractors to actually search. And then we ask them to include the regulatory office as well. And this is the ODNR in Ohio. In Oklahoma, you may want corporation commission filings and stuff. But all of these go into our abstract to make sure we're giving the best product we can. There's some additional ones. We want some tax information and stuff like that. And I didn't set out every office we search, but as you can tell, there's a whole list of them. And you just want to make sure you meet your business needs that you have. So our cover page here also includes the legal description. You can see it gives you the tax parcel, the acreage, and the section, township, and range, along with the county in Ohio that we're working. It also includes the certification dates, and it gives me the abstractor names. All of that's very important for the title attorney to know their certifications, and for us to know if we need to supplement at some point in time. And then finally, the abstractor name is something that we've asked for, because if we see a trend or if we're seeing issues in multiple abstracts, then it helps us and the crew chief pinpoint that, and they can take care of it the way they see fit. Finally, the product that we're putting together here, it's a run sheet. It's all the copies of the documents, utilizing compiling that ownership, and it's going to give us the maps, regulatory records, and anything else that we've asked for. So now we're going to move on to formatting for attorney review and adjusting the abstracts. So number one thing I'm going to tell you here is work with your title attorneys and work with your abstracting company to create a clear, consistent, and efficient product. You want this abstract to be easy to use and be very user friendly. And that's one of the biggest keys in what I say, aligning your abstracts with your title opinions, because the easier it is for your attorney to process that information, the more efficient your attorney is going to be, and the cheaper it is in the long run for the company. So when you're looking at Runsheet organization, what records do I want in there? Again, I know this seems a little repetitive, but these are all questions that you're going to want to answer along the way. And what is the pertinent information that you're going to want from those records? Are you going to want certain dates? Are you going to want recording info? Are you going to want notes? And as you can see on comments and notes, this is something that can get very tricky. I've had abstractors who want to regurgitate the entire deed for the attorneys in their run sheet. This personally is something I don't like to see, because I want to ensure that my attorneys are actually reading the document, but I do want them to flag something for my attorney if it's going to help them and speed them along the way. What secondary sources am I going to include? Again, for us, I use the example of heirship information. This is something with the case law that's come out from the Marketable Title Act and the Dormant Mineral Act in Ohio that is very relevant. We have a standard on heirships. We ask that certain information be included, and we ask that certain information be formatted in a certain way and placed in those abstracts. So once you have some of these secondary sources, the question is, do I create an entry in the run sheet? And this goes back to what I was talking about, my conversation with that attorney. And that's a hard thing to juggle, because some of the sources are very pertinent, and you can put that in your run sheet because it's going to let the attorney go to the next place. And some of them are there for just informational purposes, and maybe you don't want to, and maybe you just make a note about it and how it would relate to another document. And then let's say you do want to make that entry, how or where do I put it? And that's something that oftentimes you can work with your abstractor or your crew chief, or if you just have an understanding of what these documents are that you're asking for, you'll know how to put it in there and make it flow for the attorney. So then going to the order of information. So this is something that I've seen done different ways as well. Some people prefer that the abstracts are built by instrument date. Others prefer that they're built by recorded date. Personally, I prefer them to be built by recorded date, because if something is executed but not recorded for many years, for notice purposes, it would be a red flag potentially for a title attorney, and it may lead to an objection and a title requirement. And then, do you want it to be your oldest instrument first and work its way down? I've seen abstracts done in different ways. It's really just personal preference on a lot of this stuff. But it's little things like this that will make it much easier for the attorney. And sometimes ask the attorney. They may tell you, because they may have a certain way that they chain their records and how they look at things. So then next we'll move to document organization. And this may seem a little odd that I'd have something like this in, but it comes down to what format are you going to put it in, and how are you going to compile those records. And you can see the next bullet point is it going to be a single PDF versus separate documents? And I've seen it both ways. And I know with today's technology with Adobe, you can make these massive PDFs. They can all be bookmarked, and you can have everything you need right there in one document, and you can kind of work your way through it. We've had many attorneys tell us they actually prefer to have the separate document so that they're not having to wade through this massive PDF and go back and forth with the bookmarkings. And as you can see there to the side, the folder structure that we've set up, this is in working with our abstractor, working with our attorneys, and we have a specific naming convention, and we actually classify each document individually and have that tied to the run sheet so that they know where it is in the run sheet and how they can see it. And as you continue with the document organization, as I mentioned, our folder structure has a naming convention. Anything you can do to be consistent within these is only going to help your attorneys, and in the long run, it's only going to help your abstractor as well. And finally, the last point under that category is long documents. And it's, are you willing to allow limited pages of an extremely long document? And this is something that the title attorney side of me has gone back and forth on. And ultimately, we allowed our title attorneys to kind of give us their 2 cents, and we talked to our abstractors about it. And it comes down to, when you have a mortgage or an assignment, and these things are hundreds of pages long, do we really need the entire document put in there, or can we limit the documentation that we're putting in there to the pertinent pages and then supplement a note and have that available? And if the attorney needs to see the whole thing, we have it there for them. So we've gone different ways, and that's something you just have to kind of set up for yourself. Get to know what your attorneys are comfortable with, get to know what you're comfortable with, and then relay that to the abstracting company. So to go to the next slide here, this is an example of our run sheet that we use. Again, it's one from Kastner. It's the same parcel that I had pulled up earlier. You can see there's a lot of information at the top, and a lot of it's repetitive from the cover sheet, but it makes us know that it all ties together and is matching and corresponding abstract. And then you can see some of the columns that we have in our run sheet. You can see examples of what the notes look like. They're not over the top. Again, I don't want them to regurgitate the document for my attorney, but let's set out anything that may be a little odd or peculiar that would definitely help the attorney, and let them know that you're seeing the same lands conveyed, or maybe when the land changes. And you'll see how they reference, maybe they have a map, or maybe they've included a miscellaneous document for that actual entry. Okay, we'll move on to the next part, and that's the actual title opinion. So you've gathered up all your history, you've gathered up your knowledge of the area, you've gone out, you've talked to people, you've seen the courthouse, and then you've built your abstract. You've set out the standards for your abstracting crew, you know what you want, you've talked with your abstractor, they've built you the product that's going to make your attorneys the most efficient, and then you're going to get your title opinion. So as you can see here is the definition of a title opinion, and it's an expert special knowledge. And it's a document prepared at the client's request containing a lawyer's understanding of the law that applies to a particular case. And obviously for land, it's based on the laws of the land for the area you're working. So again, this starts out very similar to how we did the abstracts. You need to come up with some kind of standard or guideline, and it's only going to help keep it organized. Make sure your attorneys know your expectations, and you will all be aligned. You take the same aspects you did in building an abstract, utilize the knowledge of the area and the laws that you've gained, apply that, and then work with your attorneys in the discussion. They may be familiar with the area like we talked about. They may have written several opinions for the area that you're getting into. But again, I start small. Come up with a naming convention. It's something simple, but it can help you stay organized and easy to track. Next is, again, we talk about scope. Well, maybe you're going to want your opinions written on a section basis. Maybe you're going to want it parcel by parcel. Maybe you're going to want it lease, or maybe you're going to do a unit opinion. And you don't necessarily have to have your abstracts done the same way to have the attorney write an opinion based on one of these. You could have individual parcel opinions put into a unit opinion. Again, you just have to find what your business needs are, have the discussions with your attorneys, and make it work for you. Next is you're going to want to create certification date standards. And what dates do you want in that title opinion? On the next topic would be your abstracting materials that you want them to review. Are there going to be recorded documents? What secondary sources do you expect that attorney to review? The airship materials, that you're going to have included? How do you want them to handle it? What should they expect? Are these going to be informational documents, or are these going to be pertinent entries into your run sheet? And then how are they to deal with taxes? And define your expectations for all of this. Anything that you're going to put in that abstract, make sure your attorneys understand how you want them to utilize it or what you're thinking about in having it included. And again, it goes back to some of the things I've picked up over the years and some of the conversations I've had with my attorneys. But I think one of the most important parts here is if your attorneys know your expectations, then you're going to be aligned with each other, and it's only going to make the end product be that much better. Next, it's determine the interests that need to be included or excluded. And the reason I say included or excluded is I want to be very careful here and make sure that you don't kind of leave it up or open for interpretation. And it's really going to come down to what ownership do you want to see? What aspects of the opinion are important to you? Next is determine what relevant documents you want that attorney to include, or relevant exhibits, I'm sorry. For us, for instance, we have the attorneys include a tax map that identifies the parcel with every title opinion. I've seen exhibits include the materials examined. I've seen the exhibits be the actual lease tabulations and the assignment tabulations. You just have to set out your standards, your guidelines, and what you want the attorney to do, and set it up for what you need for your business. Again, the last topic here is thresholds. And this is something that relates back to my abstracting thresholds for like coal. There's certain things that I don't need the attorney to opine on, or I don't need the attorney to review, because we've deemed it that in certain situations, it's not really a business issue and there's no risk involved. Next slide here is an example of one of our title opinions. This would be the first page. You see this is done by Martin Legal Group. I've worked with Brandon Martin for a long time. And again, has given us a consistent high quality product. I appreciate that. As you can see, this is the corresponding opinion for my abstract example from the other slides. And it's done on an individual tax parcel basis. So for every abstract I get an opinion that coincides. The opinion should utilize and apply all the state law, including statutes and any kind of case law or precedent that's out there. Again, the attorneys need to rely on the title standards. And if you understand your title standards, then you can also be in line with your title attorneys. They'll have to do the statutes and then again, case law and legal precedent. The title opinion for us defines the materials examined. You can see that at the bottom 3 paragraphs there. And it sets out that there's a title run sheet, it was the Jefferson County records, and then there was a tax document included. And again, you can have that in exhibit or find out where you want to put it in your opinion. And we'll talk a little bit more about that stuff in the formatting aspect here. Next, the title opinion for us provides legal description, as you can see there in the main body of the subject lands there. It'll have the vesting deed information. It'll have our certification dates that are important for us. And then it'll have any requested exhibits at the end of the title opinion that we've asked for. And again, the final product here is a concise document that sets forth the ownership with any irregularities or defects in the chain of title or in the ownership. And I really key in on the word concise. I want it to be clear and simple and easy for the end user to follow. So going to the next slide. So again, we're going to talk about formatting the title opinions. And this is really formatting them for internal review and then adjusting the opinions as things change. So similar to what you did in the abstracting aspect of it, when you're working with your crew chief to kind of lay that out, you're going to want to work with your landmen or your in-house attorneys or your in-house groups that are going to rely on these title opinions. And then you're also going to want to work with your title attorney who's actually writing it to create this concise, consistent, and effective product. The structure and organization of that product is something that you'll need to work through and make sure you have it the way you want it and it meets the needs of your business and how you need to relay that information to the next user. And the questions I would ask myself there are, what ownership interest do I want? Do I want surface? Do I want oil and gas rights? Am I going to limit my oil and gas rights? Do I only want to see a certain formation or a certain depth? Do I need coal included? And again, I know I've used coal many times throughout this, but coal is a very pertinent thing for us in Ohio. And it's an easy example of a different type of ownership that I would like to see. If you look to the left there, you'll see an example, or sorry, to the left. On the right side of the page, you'll see an example of our ownership from one of our opinions. Again, the corresponding opinion you saw from the Martin Legal Group. And you can see here that we've asked for surface ownership. We've also asked for oil and gas ownership, the royalty, and then the working interest. Pretty standard, really. We do have a depth split here, but the rest of the opinion, I can assure you, actually includes the full depths. I don't limit anything for our title opinions, and that's mainly due to the case law that's come out because of the Dormant Mineral Act and the Marketable Title Act. Also very important for me to have that surface ownership due to those two acts as well. So again, you have to know the law, have to know what your expectations are and what you need in there, and then lay out for the attorney how you want to see it. One of the other things I bring up here in your structure and organization is, being in Appalachia, I've seen this a lot, is a history of title. And sometimes the attorneys will derain title in a brief summary for you and key in on the major conveyances or documentation. And it can be a handy tool, and it really just comes down to a personal preference and how you want your title opinion structured. And then the next thing I look at is, what do I want to tabulate? What do I need the attorney to break out for me? What do I need them to really kind of set out on its own so I can take a quick look? Do you want leases and assignments? Do you want taxes? Do you want mortgages? Do you want unreleased oil and gas leases? Do you need litigation to be flagged? What about easements or right-of-ways? And there could be other encumbrances that you may be interested in. Really just comes down to what you need to see, and just ask them to set it out and tabulate it in the manner that you need to meet all of your business needs after you've discussed it with your end users. So the next slide here, we're just going to continue on the formatting. I think this is one of the most important parts of formatting the opinion. Obviously your numbers, there's only so many ways you can really show that. Your tabulations, you can really save yourself some time in reviewing, depending on how you structure your tabulations and which ones you want included. But the meat of these opinions is the objections and requirements. Obviously tells you what you're going to need to work through and what you're going to need to cure. And my number one bullet point here is, you got to determine what is necessary versus unnecessary. And this is something I've spent a lot of time dealing with and working through with both my own staff and my attorneys, so that we can get to the most concise and specific opinion that we can get. Really want to take out the fluff and just get to the actual problem. And so you'll see the next bullet point I have under that is limitations versus a general comment versus a specific objection. And this all comes down to, what can I cover in a limitation or some kind of general statement and not have to have a specific objection about it? And it really just depends on your attorneys and on your area, and then also on your business needs and your tolerances. Next, I would say you need to align to your business needs. And again, you need to look at what is our ultimate goal here, and how are we going to utilize this opinion, and are we going to have applications that rely on it? How many different users are going to rely on it? And you have to align your business with the objections and requirements in it, so you know exactly what you need to carry out in order to develop those lands. Next, it's aligned with your tabulations. And this is one of the main things that gets into this limitations general comment aspect. I would see many a times my title attorneys would give me a tabulation for taxes or a tabulation for litigation or mortgages. And then I would be going down in the title opinion, I'd get to the objections and requirements, and they would start an objection about mortgages, and then the requirement would be there's none, advisory only. And so my question always was, why are you giving me an objection when there's nothing to object to? And that was one of my big things, and that's what I mean by aligning with your tabulations. Take out those boilerplate, take out the fluff. I don't need the land team or my team or anybody else in our business going through a title opinion and 50% of the objections are advisory and don't pertain to anything. Now, there's certain aspects of the title opinion that you may need an advisory objection, and the attorney's not going to take it out. And that's what gets into maintaining the integrity of the opinion. There's certain aspects of it that they're going to keep in, and you maintain that integrity. It is a legal opinion. There are certain things you do need in it, as well as you need to maintain the attorney coverage. And what I mean by that is the attorney has to actually, they need to represent themselves that for legal purposes, they have given you this information and it applies so they can be protected, that they pointed something out and they didn't miss it. And it kind of goes into, their liability aspects. And then set up any potential thresholds for irregularities that you may be comfortable with for objections and requirements. And that's something you'll just have to do, again, based on your internal discussions and your business needs. So the next topic under the objections requirements is actually formatting and style of objections. And it really comes down to personal preference. Do you have a specific layout? Is there a way you want your objections to look? Is there a way you need them to look? What are people familiar with? And then next, it gets a little bit more detailed here. There's specific details or specific analysis you're looking for. For me, I absolutely look for specific analysis, especially when it comes to things like the Marketable Title Act or the Dormant Mineral Act for us in Ohio. I have to have things analyzed under the case law that is at the time and how it applies, and I need to see very specific things in that. And along those lines, getting to that specific analysis, it's discussions on the interpretation and the assumptions of the law. And so again, we pull our attorneys in and we sit and talk with them when the new case comes out or something's been changed. And we want to know their thoughts as much as ours so that we can both be on the same page. We get the analysis we need in a way that makes it easy for the end user, and then we can make sure our opinions are the most effective. But the final point here is really important. When you're doing that, you cannot dictate the attorney's interpretation or his or her conclusion of law. And it's really important to keep that in mind. You may be able to kind of, guide them. You're going to ask them to, rely on specific information, or, hey, there's a document here. I want you to, take this into account when you're giving me your opinion, but you're not telling them how to interpret things. You're not making them reach a certain conclusion. You need to have that attorney's freedom to maintain not only the integrity of the opinion, but also you're not just dictating to them what it needs to be. You're actually receiving an honest product from them. And then lastly, it's adjust. Just like with the abstracting standards, you need to adjust your opinions and update your standards and formatting for anything that may come at you. Again, adjust to the area. Maybe a new play, maybe a new state. Change with the case law. Again, this is important as things continue to develop. Just in the last couple of years, I have changed our abstracting standards and our title format a couple different times. And I actually have a new formatting thing I think we're getting ready to implement on our title opinions. So this is something that we continue to review as our business needs change, which is the very next bullet. Then we'll look at it and do how has this case law affected us? Is there something that our business needs differently? And then are people seeing something in their opinions that ask us to change it? And you just have to be flexible with that. And then finally, maintain that consistent communication with your title attorneys. As I talked about, we bring our attorneys in when there's a major decision and we discuss the interpretation and the assumptions. And it only helps us kind of build that relationship with them and make sure we're all aligned and we're actually getting that opinion put into the specific way that we need it. And that's really what the whole thing here is. As you're aligning everything together, you're kind of breaking it back apart so you can get the end result that you need and get that information to the right people in your company. Next slide. This is an example of some of our objections and requirements. And again, the very first one here is advisory. So in this particular instance, it's not something that's related to one of my tabulations. It's basically telling me that the land's unleased. And that's something I don't mind them flagging for me. You can see it in the numbers, but this is reiterating with us, hey, we need to go out and do something. And you can see here that the tax objection relates to a tabulation, but there's specific reason why they would have put that in there. So next slide is the summary here. And I know I've kind of hit several items over and over again, but it's really, I'm trying to build on that mentality that all this kind of plays together, and you really need to align everything. But at the same time you're doing that, you're aligning things by breaking them down. You're understanding the little nuances of each aspect of what goes into this. So again, learn and understand the area and the play. Gain that knowledge, get to know the courthouses, get to know the areas, and know what those little nuances are going to be. Determine your business needs. How are you going to structure things? What do you need them to be structured like? Who's your end user? How are these products going to be used? Anything that goes into that. Are you going to use a certain computer application for different aspects of your business? Next is create standards and guidelines. And this just helps you be organized. It helps you maintain consistency. It defines your expectations. There's no room there for error. Everyone knows what the expectations are, what they need to deliver, and everybody is on the same page. Next is collaborate and communicate. And again, all throughout this, I've said talk with your attorneys, talk with your abstractors, talk with your co-workers. Build that rapport, maintain it, and rely on them. They're a resource. They're also the user of the product. So they're going to have more input on a day-to-day basis than anyone else can for you, even maybe more so than yourself. Next is stay current on changes in the law. Anything that happens, whether it be statutory or case law driven, stay on top of it. Make sure you can adjust and make the necessary changes you need, whether it be to your standard, to your actual format of your product, or just to a way you're going to alter your process. And then finally, be flexible. Be willing to make adjustments. And this is probably the biggest thing. I've been doing this for a long time. I've worked several different states, and I am in no way naive enough to think that I have it all figured out. And like I said, we're getting ready to make another adjustment to our title opinions, and we recently just made adjustments to our opinions and our abstracting standards. So you have to be willing to make those adjustments for whatever reason to make your business more efficient, make the product better, and it ultimately just serves the purpose that you're trying to get through with that title opinion or that abstract. So that's the end of my presentation. Again, I'd like to thank you all for joining me. I'd like to thank the OCAPLTA and Tammy for introducing me. And if you have any follow-up questions, there's my contact info. Don't hesitate to reach out. Again, thank you very much.